Getting the flat keys does not end the right to compensation. At around 10 o'clock at night, a man was standing on the balcony of his new flat. The keys were in his hand, the city lights were in front of him, but there was no happiness on his face. This was the very house for which he had broken his savings years ago. He paid EMIs, paid rent, and trusted the builder's promise every month. When the possession was finally received, the society said, "Now that you have got the flat, what is there to complain about?" But a question remained alive inside the buyer. Does the account of years of delay, extra expenses, and mental stress end as soon as you get the keys to the house? On this very question, the Supreme Court gave a decision on the 4th of June 2026, which gave great legal power to home buyers. The court clearly said that taking possession does not prove that the buyer has surrendered all their rights. If there has been a delay, the claim for compensation can survive. This case was connected with TKA Padmanabhan and Abhiyan Cooperative Group Housing Society Limited. The matter started with a housing society in Delhi and a flat in a Dwarka project. In January 2003, the buyer became a member of the society. He made the payment for the flat, and on the 27th of February 2004, an agreement was signed between the parties. Flat number 232 was allotted, but a dispute arose over the delay regarding possession. The buyer considered this not just a wait, but a deficiency in service. On the 8th of August 2005, the buyer filed a complaint in the District Consumer Forum. The demand was compensation for the alleged delay in handing over the flat. The builder or society side said that there is an arbitration clause in the agreement, meaning the dispute should go to arbitration, not to the Consumer Forum. First, the District Forum rejected the application regarding arbitration, but later the matter came up again, and the parties were sent to arbitration in 2009. The Delhi State Commission upheld the same view in 2013. Then in 2016, NCDRC dismissed the revision petition. NCDRC said one more thing. It held that since the buyer had already taken possession, he was no longer a consumer at the time of the complaint. From here, the story reached the Supreme Court. And the Supreme Court asked, if the complaint is for delay compensation, how did the claim end just by getting possession? The court said that the buyer's complaint was not just for the delivery of the flat. The grievance was that possession was received late, and compensation was required for that delay. Meaning, the loss was connected to that period when the buyer was waiting. Getting the keys later cannot automatically erase that old loss. This thing sounds simple, but its impact is very big in real estate disputes. Many buyers used to feel legally weak while taking possession. The builder used to say, first give the money, clear the dues, sign the possession letter, only then will you get the keys. The buyer would sign out of fear. Many times, the language in the possession letter was such that it made it look like the buyer had surrendered all claims. The buyer would take the flat out of helplessness. Because the house gets ready after years. There is family pressure. Rent is going on. EMI is also going on. In such a situation, the buyer wants to stop the fight. But the Supreme Court's message is that taking possession and surrendering rights are not the same thing. The court did not say that every buyer will automatically get compensation. The court said that the claim must be heard on merits. Meaning, the Consumer Forum will see whether there was actually a delay or not. Due to whom did the delay happen? Was the possession accepted unconditionally or with a protest? The forum will also see whether the buyer is legally entitled to compensation or not. The decision will be on the basis of evidence, not just on the basis of possession. This is a balanced approach. Through this, the buyer gets a door, but the builder also gets a chance to present a defense. The Supreme Court set aside the old orders and restored the complaint of 2005. The matter was sent to the Dwarka District Consumer Commission. The court said that the complaint is very old, so an effort should be made to decide it within 1 year. A buyer who had filed a complaint in 2005 got to hear from the Supreme Court in 2026 that his claim is worth hearing. Imagine, this is not just a legal victory. This is the story of those people who stick around in the system for years. The second big thing about this decision is regarding the arbitration clause. An arbitration clause is often written in builder-buyer agreements. The builder side often says that if there is a dispute, do not go to the Consumer Forum, go to arbitration. The Supreme Court said that an arbitration clause by itself cannot end the jurisdiction of the Consumer Forum. The Consumer Protection Act provides a special remedy. This remedy cannot be easily taken away by any condition of a private agreement. This means the buyer should understand that they do not need to panic seeing an arbitration clause in the agreement. By taking legal advice, the consumer route can also be explored. This decision is also important because in real estate, the agreement is often drafted by the builder. The buyer has very little negotiation power. The person buying a flat is usually buying a dream. He does not understand every line of the legal clauses. The builder is professional, the buyer is emotional. In many agreements, the builder's liability for delay remains limited, but heavy interest is charged on the buyer's payment delay. This very imbalance makes frameworks like consumer law and RERA necessary. The law does not leave the buyer completely helpless. There is important protection against delayed possession under Section 18 of the RERA Act, 2016 as well. If the promoter does not give possession at the fixed time, the buyer has options. The buyer can withdraw from the project and ask for a refund with interest. Or they can stay in the project and claim interest for the delay period. But the roots of both RERA and the Consumer Forum are technical. Which forum is better depends on the facts, project status, and claim type. This order of the Supreme Court strengthens the relevance of the Consumer Forum again, especially in those matters where the complaint is connected to service deficiency and compensation. Now understand its practical meaning. If the builder gave the flat late, the buyer will not remain quiet just because the keys have been received. If the buyer paid rent because of the delay, suffered EMI and rent together, and faced family stress, then they can raise a claim for compensation. If the promised amenities are incomplete, construction quality is poor, or basic services are delayed, then these too can create questions of service deficiency. But every complaint will become strong only when the evidence is robust. Just anger is not enough, documents are required. The buyer should keep the allotment letter, builder-buyer agreement, payment receipts, bank statements, possession letter, emails, and delay communication safely. If the builder asked for extra charges, then the demand letter, receipt, and objection mail must definitely be saved. If the buyer had protested while taking possession, then its written proof can be very important. Many buyers make oral complaints. They go and talk in the society office. But in court, a written record comes in use much more than oral frustration. Therefore, it is better to keep everything in an email or registered communication. The objection should be registered in short, clear, and respectful language. If the builder says to clear all dues otherwise possession will not be given, then the buyer should document the payment and the objection separately. There is a psychological impact of this decision too. Now the buyer can feel that taking the keys is not a legal defeat. Earlier people used to think that if possession is taken, the case against the builder will become weak. The Supreme Court has reduced this fear. But this does not mean that the buyer should become careless. The limitation period, documents, and legal strategy are still important. Delay itself is a big problem in property disputes. This case went on from 2005 to 2026. Therefore, timely action is always better. If the project is RERA registered, the route of a RERA complaint should be explored. If there is a consumer grievance, the Consumer Commission route can also be relevant. Many times buyers confuse both systems. RERA is focused on project regulation and promoter accountability. The Consumer Forum can hear service deficiency and compensation claims. It is necessary to choose the right route by taking legal advice, because a wrong forum or weak drafting can drag the case long. This decision is a warning for builders too. It will not be easy to run away from responsibility by handing over possession. If the delay happened due to genuine reasons, the builder will have to keep evidence. Approvals, force majeure, buyer default, and project records should be clear. But if the delay happened due to poor planning, fund diversion, or negligence, then the buyer's claim can be strong. This decision gives a message to the real estate market. A house is not just a concrete structure, it is the buyer's life planning. A delayed flat can change a child's school planning. It can affect the medical treatment of elderly parents. It can shake the family's budget. Many buyers keep paying rent for their old house and also the EMI for the new house. This double burden can go on for years. For a builder, delay can be a project issue, but for a buyer, it is the pain of daily life. Therefore, the idea of compensation is not punishment, it is accountability. The one who made the promise will have to give an answer for the delay. The Supreme Court also made it clear that a decision on merits is necessary, meaning the Consumer Forum cannot dismiss a complaint in a shortcut. The forum will have to see the evidence. It will have to understand the nature of the delay. It will have to hear the parties. Then it will have to give a legally reasoned decision. This point is connected to the basic spirit of justice. A person cannot be turned back from the door just on a technical ground. This decision is a shield for home buyers, but it will become a sword only when they are prepared. Reading the agreement before booking a flat, checking the possession date, verifying RERA registration, and understanding penalty clauses are now necessary. At the time of possession, the OCCC promised amenities, maintenance charges, and extra demands should be carefully checked. If there is language like no claim or full satisfaction in the document, it is better to take legal advice before signing, because a single line from the builder can complicate the buyer's years-long claim strategy. Even so, the principle of the Supreme Court gives relief to the buyer. Possession does not mean an automatic waiver. This ruling is a hope for those lakhs of people who have shifted into flats but are still carrying the burden of delay inside today. Many people think, what is the use of filing a case now? But the law says if the right survives and there is evidence, the way is not closed. This decision will also build pressure on the high-handedness of builders. Now, it will not be easy to use the possession handover like a final escape gate. If accountability increases in the market, genuine developers will benefit, because the difference between responsible builders and careless builders will be clear. The trust of the real estate sector will not return just through glossy brochures. Trust will return when promises are fulfilled on time. The buyer too can no longer take a decision just by looking at a sample flat. He will have to see legal documents, delivery records, and builder reputation. A house can be the biggest purchase of a lifetime. Therefore, despite being an emotional decision, it is a legal decision. The Supreme Court reminded exactly this in this decision, that a consumer is not just a person making a payment, but a citizen holding rights. Getting the keys is not the end of the story. Many times, it can also be the beginning of the real legal chapter. If the house was received late, if a loss occurred, if promises broke, then a way to raise a voice can remain with the buyer. And this is the biggest message of this decision. If the house of dreams is received late, it is not necessary for the buyer to remain quiet. Because in the eyes of justice, the years of waiting do not disappear just by getting the flat keys in hand.
If this video has taught you something new, or if you feel this information should reach more people, don't forget to like and share the video. Your small share can become valuable and useful information for someone else. If you have any questions related to this topic, or if you would like to share your opinion with us, be sure to write in the comment box. We read every question and suggestion from you, because your feedback inspires us to create better content. And if you want to keep receiving such interesting and reliable information about business, the economy, and the world in the future, then don't forget to subscribe to our channel GRT Business and also press the bell icon so that you get notifications of every new video directly. At GRT Business, we always strive to provide you with accurate, balanced, and reliable information. Our news and analysis are prepared based on information obtained from various news agencies, public sources, and public opinion. We make every effort to verify and validate each fact as much as possible. But in case of any possible error or dispute, the responsibility lies with the respective sources. Our only aim is to present you with a correct and trustworthy perspective so that you can understand any topic better.